Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about murder. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Egal was charged, along with a number of co-conspirators, in the beating and then stabbing death of a man. During the course of the trial, counsel for one of Mr. Egal's co-accused sought to introduce prejudicial statements during the course of cross-examination. Because there are much wider latitudes in relation to cross-examination, the statements were admitted into evidence for the purposes of cross-examination to allow the co-accused to make out his defense. The problem was that the statements were prejudicial to Mr. Egal's case and suggested that perhaps Mr. Egal had been the person responsible for the murder. As a result of this, Mr. Egal appealed his conviction, arguing that the statements were not properly admitted because they were prejudicial to him, even though they were beneficial to the co-accused in his case. This case obviously deals with very important issues that relate to the joining of individuals in trials where their interests are adverse to one another. Oftentimes you'll see multiple people charged on the same information or indictment, where one person is pointing the finger at the other. And this can, to some extent, be beneficial to the Crown because it allows the jury or the trier of fact to choose one version of events and believe one individual over the other that leads to a certain conviction. But strategic decisions by the Crown to try individuals together are also encouraged by the court system as a result of the fact that they reduce delay, limit the number of cases in the courts, and allow evidence to be led against one individual at the same time that it's led against another individual. So there are also benefits to this approach. But where the approach pits accused individuals and the evidence that's going to be led against them, which wouldn't be admissible as part of the Crown's case, but would be admissible as part of a defense case, that raises significant concerns about how to achieve that process fairly while balancing all of these competing interests that arise in criminal cases. And there needs to be more clarity in the law in relation to the test for the admissibility of evidence that's prejudicial to one accused by the other accused individual to whom it's beneficial, to determine whether it's fair to continue with prosecutions that are joint in circumstances where these types of situations are to occur without implying or requiring the accused individuals to apply for severance in advance of the trial, not knowing what the strategy of the other individual might be and not knowing that those statements may come up in the course of trial. There has to be a better way. This was the opportunity for the Supreme Court of Canada to tell us what that better way might be. And yet we don't have any answers from the Supreme Court of Canada on this issue, and unfortunately Mr. Egal lost his opportunity to have this case heard by the Supreme Court of Canada, and consequently has to deal with the results of his conviction. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.